Hello, Colorado Realtors. Welcome to Legal Bites. I'm Scott Peterson. Today we're going to talk about the contract to buy and sell, and specifically paragraph 5.2 of the contract to buy and sell. As all of you guys know, 5.2 is the loan objection clause in the contract. Anybody that's heard me speak before around the state knows that this is one of my favorite topics because I think, unfortunately, it is a clause that is often misunderstood or misinterpreted by sellers and even some realtors, unfortunately. So I want to spend a few minutes today kind of talking you through it and helping you understand some of the pitfalls, specifically for a seller as it relates to paragraph 5.2. So I call it the buyer's hammer because the language has really expanded over the years to give a buyer sole subjective discretion related to every aspect of their consideration of a new loan. So if a new loan is a condition of a contract to buy and sell, a buyer has the sole subjective ability to analyze every aspect of that new loan under paragraph 5.2. So that's going to include the loan's availability, right? Is the loan available to the buyers? Will the lender actually give the loan? That's more the kind of bank approval. That's included in 5.2. But it also includes the buyer's payment, mortgage amount, the interest rate that the buyer is going to be obligated to pay, as well as any other terms, conditions, and costs of such new loan. If any of those items in the buyer's sole subjective discretion is not acceptable to buyer, then the buyer has a right up until the loan objection deadline to terminate the contract and receive a full receipt of their earnest money. So very, very broad contractual discretion that a buyer has been given as they consider the new loan. So what do we have? We've got some challenges related to that. As you guys all know, most often the loan objection deadline is usually the last contract contingency that is available to a buyer in a contract. It's often set pretty late in the due diligence period. The reason for that, of course, is because of the loan, the requirement that the loan is available by the lender, that the lender actually will underwrite and finance the property on behalf of the buyer. That goes to the availability. So obviously, if the loan's not available to the buyer, they need an ability to terminate the contract often very late because the lender has to go through the appraisal process and the other parts of the underwriting process to get there. So as a result, the loan objection deadline is often set very, very late in the transaction. But now that language also includes the buyer's right to analyze all of those other pieces of the loan. So it's subjective to buyer. And that's very, very hard for a seller to question. If a buyer terminates a loan because they decide that the interest rate is too high, as an example, or that the mortgage payment is going to be more than they thought that they were going to be able to afford when they entered into the contract, then they have a right in their sole subjective discretion to terminate the contract and receive receipt of a return of their earnest money. And because it's subjective discretion, it is very, very difficult for a seller to question that in keeping the earnest money. It has to be done in good faith, of course. You have to exercise that in good faith. Paragraph 29 of the contract requires that the parties act in good faith with respect to all of their obligations to each other, including financing conditions. But good faith in and of itself is a subjective standard. And so it's a little bit difficult for a seller to contest a buyer's exertion of a subjective loan condition standard with a good faith standard. And unless there's a lot of earnest money that's at stake, then it's often not going to be worth it for a seller to contest the buyer's exertion of a loan objection. So got to be done in good faith. What's the takeaway from this? You got to communicate. As I mentioned at the outset, some realtors don't understand. I know most of you that are spending time to educate yourselves and that are members of the association, you go out and get education and you understand the full implications of paragraph 5.2. But I think oftentimes sellers don't. They don't get how broad and subjective that is and how much leverage and right really a buyer has to terminate a contract based on their subjective analysis of the loan. It is not just lender approval or disapproval of a loan, and that's not what that deadline is for exclusively. It's so much more. So communicate with your sellers. Make sure your sellers understand paragraph 5.2 at the time of execution, and so that if they end up with a late termination based on loan objection, they're not blindsided by that, and that you've walked them through that part of the contract. real important piece of things. So consider that, sit down with your sellers, make sure they understand that to the extent that you can back, as a seller's representative, that you can back up that loan objection deadline, shorten that as much as possible. You're going to be doing your client a real favor in the long run. Anyhow, hopefully that helps clear up some confusion related to 5.2 of the contract. As always, if you have additional questions, the Car Legal Hotline is available from 9 to 12 and 1 to 4, Monday through Friday, and so please feel free to utilize that. Thanks for joining us for another edition of Legal Bites. I'm Scott Peterson.
Curtis Zimmerman, and I'm very excited to be one of the keynote speakers at the Colorado Association of Realtors Fall Conference and Expo in Bloomfield, Colorado. Now, let's remember that these conferences are for you, and if you've been before, you don't want to miss this one. I've seen the lineup of amazing world-class speakers. It's going to be fun, it's going to be interactive, and this is where you get the chance to take your business to the next level. The networking is going to be amazing. I look forward to seeing you there.